One of the things I find interesting about YouTube is at times you can find yourself watching videos of goings on in a courtroom, the justice system at work, or not at work, so to speak. We're going to watch one such event unfold as she breaks down when a protective order stops her from controlling her ex. This should be good. And here we go. Oh, hey, minions. Nice. Well, here we go.
Of stealing my dogs and selling them, which she has in the past.
Did she threaten that, or you're just bringing that up now?
No, she said that.
Can you hear us, sir? Hello?
Yes, I can hear you.
Give me one moment here and I'll call us into session. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, March 18, 2024 at 11 a.m. Two cases for
So
these
that was a week
parties,
ago.
2024 391 PP, John McKediac versus Lindsay McKediac, and 2024 113 PP, Lindsay McKediac versus John McKediac.
Okay. Good morning to both of you.
All right.
Court will note that in the 391 PP case involving Mr. McKediac, he's filed a petition for a personal protective order. And in the other case, the 113 PP, Ms. McKediac has filed a motion to show cause for violation of the PPO. Ms. McKediac, I'll let you know, your proof of service shows service on the respondent on March 14, 2024, which was last Thursday. That is improper service. So I cannot take up your motion to show cause on today's date.
Okay.
So the only issue the court will be addressing today is the petition in the 391 PP case. So Mr. McKediac, in this matter, will proceed on your petition. Do you wish to render any testimony?
I mean, no, other than what was stated in the PPO.
Well, you're gonna have to enter some testimony because I won't do it just on a written statement. So what we're gonna do is have you sworn in, raise your right hand, be sworn, and then we will proceed.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Okay. Go ahead, sir. Tell us what you'd like us to be aware of. What happened that you should be getting a personal protective order?
So we've been separated. She's came to my place of business, unlawfully removed vehicles.
Okay, hold on a second. When you say she, obviously
Lindsay,
she doesn't mean anything. You have to tell me who she is.
okay, I apologize. Lindsay McKediac had came to my place of business and removed vehicles. She has pending cases for that. From my understanding, Lindsay McKediac also has another PPO placed on her by somebody else, and Lindsay McKediac still has possession of her firearms and continually calls me, threatens to shoot me, threatens just continually harassing me and harassment. And then, you know, she feels she needs a PPO because she's scared of me, but she's coming to my house, driving by, calling my phone all the time by block numbers, no caller ID numbers, and threatening friends and associates. And I'd like to say or show and sending mail to my house that says happy birthday, hubby, love you, with balloons and hearts.
Okay.
With her name written on the front of it.
Okay.
And she has a PPO on me, but she continually violates it. So I feel like I need to protect myself from her feeling like I have no recourse because she can do whatever because she has a PPO on me.
Okay, you've stated that there were various dates that she called and threatened you and things of that nature. Do you have dates for that, sir?
Yeah, it was, I want to say February 9th or 11th.
Okay, and what does it pertain to? Because you made a lot of allegations, so I need to know if it was you say what date, what was the date again?
I want to say February 9th.
Okay, February 9th. What happened on February 9th?
I had received a bunch of no caller ID calls, and I wouldn't answer
Okay, how did you know it was her if you have no caller ID on there?
because my girlfriend had answered the phone and had her on speaker, and they commenced to argue and threatening each other. And
Okay,
Lindsay threatening her.
so did you hear the conversation when they were on the speakerphone?
Yes, I was in the vehicle when she answered it, and it was on my phone.
Oh, okay.
And also,
Hold on. There's
Sorry.
a lot of things we have to establish. You just can't.
Okay.
Well, did you recognize respondent's voice on the phone?
Yes.
And what did she specifically say to you? I'm not concerned about what she said about your girlfriend because she's not a party to this. So what did she say to you or make any threats to you?
The typical, if I come around, she's going to shoot me, that she's going to make sure I lose my business. She takes half of it in the divorce because I filed the divorce on her. And also numerous times of stealing my dogs and selling them, which she has in the past.
Did she threaten that or you're just bringing that up now?
No, she said that. Like, let your dogs be outside running loose and they'll come up missing again and blah, blah, blah.
Okay, so she threatened to steal your dogs.
Yes. And I have numerous text messages from her threatening to have me locked up again. I'm going to go away forever. Just repeatedly over and over. And then also, you know, I've had to have her removed from the shop by BCPD to where they told her if she come back on the property, she'd be arrested for trespassing. And threatening that if I didn't pay the child support when she wanted, she'd have me locked up. There's numerous calls to Tom Mize, which was my federal supervised release officer, where she called and threatened him and his supervisors to do something about me and when I pay my child support, and trying to turn in evidence to have me incarcerated again.
Okay.
For violating no contact.
Now, on the letters that you claim were delivered to you, when were the dates of those?
This one was March 1st, 2024. And I have the picture of it. It's in her handwriting. Well, this is the actual envelope. This is the handwriting. And then this is also her handwriting and her little messages at the top, whether to cause problems between me and my now girlfriend or just antagonize and upset me.
Okay. And any other dates that you've gotten those letters?
No,
Okay.
that was the most recent.
So effectively, if I'm correct, is that you've received numerous phone calls, you've had visits at work and letters in this particular matter. Is that correct?
Yeah. Yes. Well, and also her unlawfully driving off with the vehicle that I was in possession with.
Well, that's for another matter. That's going to have to be something that's resolved through the divorce action.
Oh, yeah.
Okay.
Well, she was charged with that.
Okay. Okay. Anything else, sir?
Well, Your Honor, I wasn't in the state the date of the issue of the original PPO.
Okay, we're not addressing that today, sir.
Okay. Okay.
There's nothing in your petition. You didn't file a motion to terminate their PPO, so I can't take that up today.
Oh, okay.
And it's something to note. You know, if I had a little bit more free time, I would head down to the Hall of Justice and sit in on some of these cases. Some of them are pretty intriguing. Other times, you know, it could be outright boring. I remember sitting on a jury panel. I think it was back in 2007, 2008. I was an alternate, and the state had brought a petition to have someone reincarcerated in a medical facility, an inpatient medical facility, because the state feared that this person would violate terms of his probation as a offender. There were a lot of statistics involved, a lot of numbers thrown around, a lot of probability, but ultimately, the court decided that the state did not have enough evidence to prove that this individual would reoffend. So it was interesting, but at the same time, like I said earlier, it could be drawn out and boring. So.
Okay, Ms. McKediak, I'll have you raise your right hand and be sworn in, and we'll take testimony from you if you wish to give any.
Yes, sir.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Ma'am, I'll first advise you in this matter with what's been stated, only because there's a lot of things that have been stated. I want to make sure you understand that you have a Fifth Amendment right against self-incrimination, and you don't have to answer any questions that may incriminate you for any criminal proceedings. You understand that?
Yes, sir.
Okay. And I don't know if they'll come up. I'm just mentioning it because of what he's alleged. I don't want you to do anything that's going to have an adverse effect on you that you should not admit to.
Thank you.
Okay?
Thank you.
As to the allegations that he's made, have there been phone calls made with which you have threatened the petitioner?
No, Your Honor. No. Your Honor, I do not have time to threaten.
What he's saying is that, again, in the phone call, that he recognized your voice on 2-9, that you threatened if he comes around, you're going to shoot him. Did you
No.
say that?
No, sir.
Did you threaten to steal his dogs?
No, I do not.
Did you threaten to have him locked up?
No, sir, but there was a no contact order on his federal
Okay, that's not what I'm asking about, ma'am. Don't go
No,
off on tangents and stuff I'm not asking you.
You know, there's a reason why they read you your Miranda rights when you're arrested, that you have the right to remain silent. This is starting to turn into one of those instances where you have the right to remain silent, but you just don't have the ability. That's what my instinct's telling me right now. That she is just going to keep talking and talking and dig herself into a deeper hole.
Bring that up
No,
later.
no.
Did you threaten that you were going to have him removed from various jobs?
No, Your Honor.
Did you send him a handwritten letter on March 1, 2024?
That envelope is a service of my response to the divorce, and I did not write the message on the back, but that's a service for divorce. So, in which I have the proof of service, and I have my response right here, and in which it was filed and mailed to him in the envelope. And that is what that is. That is not a letter. That is the response to his divorce.
Okay.
Don't believe that. I don't believe that.
Did you, in fact, as he stated, go to the property where he was working and remove a vehicle that was in his possession?
No, that vehicle is my parents' truck.
My follow-up question at that point would be, who is the vehicle registered to?
Okay. Anything else, ma'am, that you would like to say in response to the
It's
allegation?
just, I don't threaten him, and on these dates of February 9th, February 8th, of the dog matter, of any of his girlfriend calls me, he threatens me. This is ongoing and scary, and very scary on the part of, I don't have time to threaten John. There was a no contact order with his federal.
Again, ma'am, that's not a part of today's hearing, so I don't care about what happens on his probation.
Well, what I'm saying is that there's no contact.
And I'm telling you, I don't care about what a different proceeding is. That's not involved in today's hearing.
POs, no contact orders.
Ma'am, you're not listening to me or something, because I'm saying I don't care what's happened in his other criminal action, okay? If he has a no contact order or not, it doesn't pertain to this proceeding. He is seeking to get a PPO. So anything that's happened in some other action, I don't care about.
I'm saying I've taken the measures to protect myself and get PPO orders. So that way I'm not contacting him. I am not threatening him.
Okay. Anything else, ma'am?
I do not write him. I do not call him. I do not have time. I have an autistic son that I take care of, and I am constantly being threatened. I am constant.
What does that have to do with what is going on with this current petition for a PPO? You can already see, oh yeah, I'm going through this, that, and the other. I have an autistic son. Yeah, that's well and all, but wouldn't that facilitate the ease of a PPO for the petitioner, in which case it's John, against Lindsay, and to just have it formal, saying, hey, it's in the system now, it's documented, don't talk to each other, don't contact each other. So why is she going on this tangent about what's going on in her life?
And I try to cover my butt with this. I call
thank
him
you.
the courts. So,
Sir, do you have any other witnesses or evidence to present?
So, I have respect for Judge Kirkham in this one, because he's established he doesn't care about any extenuating circumstances, just the case that's in front of him. And as far as John goes, has my respect because, you know, he's staying quiet. He's got the ability to stay silent.
No, pretty much just that envelope. You know, she filled out the front, the heart on it next to her name is the exact same hearts that are on the back of the message that she said she did not put on there.
Okay.
If I also need to drop off, I can print out all the threatening text messages she has sent from her actual number that has her photo on it to the courts if you need that for more evidence. And you can look up the police proceedings from her removing that vehicle that I was in possession of from my business.
Just to confirm, sir, was that vehicle, was it in fact her parents' vehicle?
No, they had sold it to my little brother. And then my
Oh,
little
no.
brother went to jail, and I was using it waiting on my new vehicle. And
It
she
is still titled to my parents.
Ma'am, don't interrupt. I didn't go to you yet, so be quiet when you're not asked to talk.
See what I mean about the ability to stay silent?
there is a police report and there is a criminal case against her for removing that her dad had pressed charges on her because she didn't have authority to go and remove that vehicle. And her dad returned it back to my shop after dealing with the state police at her house and taking it from
So
her.
the vehicle was returned.
Yes.
Okay.
One of the drawbacks to living in a relatively quiet neighborhood is said neighborhood is close to the Air Force Base nearby. So I'm pretty sure you guys have picked up on hearing jet noises in previous videos. I mean, it's calm enough out there. I mean, it was windy a while ago. Over the past few days, that flight operations actually had to get canceled. And continuing on.
Anything else, sir, before we conclude?
No, sir.
Do you wish to make any closing argument?
No, sir.
Okay. Ma'am, is there anything else you would like to say before we conclude?
$10 says she makes it all about herself.
That vehicle is still titled in my parents' name. And this is all to get my CPL taken from me. So, and he threatens that constantly because this man has taped me up. He has came into my home. He has beat me, abused me, tried to kill me. And that's why I have PBO orders. I am so tired. I'm tired because I raised 2 children.
You see John in the upper right panel just laughing. He knows. He knows. And that tells me that, yes, she is the one violating the PPO that she took out against him to try to make his life hell because she's under the assumption that because she has a PPO against him, he can't do anything to her. That's not how that works. It's not how that works.
And I am tired of these. I don't have.
I mean, you just got like 4 minutes left in this.
And he is doing this because if there's a PPO placed on me, then I cannot protect myself, and he knows that.
Okay. Well, in this matter, the court has heard the testimony. I would state in this particular case that, again, when the court does listen to testimony, the court notes that credibility is always an issue. Oftentimes, parties will allege that another party has lied or given false testimony. However, the court's found that conflicting testimony can occur as a result of a witness's background, perception, bias, understanding, or misunderstanding, that inconsistencies do not always determine or denote that a party has lied. It can simply be a matter of perception. Obviously, there's some inconsistencies here. The court, in deciding whether to grant a personal protective order, I can grant a personal protective order pursuant to the sections on personal protective orders, which is MCL 600.2950. And specifically, the court can grant a action enjoining or restraining a person if there is reasonable cause to believe that the individual has committed or may commit any of the acts listed under MCL 600.2950 parens 1 parens A through K.
Okay.
In this particular matter. What happens is, after listening to the testimony, the court does believe that there's reasonable cause to believe that, again, that the respondent committed or may commit any of those particular acts. The petitioner stated that there was a call on February 9, 2024, in which some threats were made, that there was a letter on March 1, 2024 that had some handwritten statements on it. The court will note that also the respondent did remove a vehicle from the petitioner's possession, which was subsequently returned to to his possession. The court will note that the respondent has stated that she did not threaten him, etc., in this matter, that in fact she didn't write on that envelope, but the court does believe that there's sufficient evidence to believe that, again, not only that she may have committed, but may commit. So the court is going to enter a personal protective order, which would prohibit the respondent from assaulting, attacking, beating, molesting, or wounding petitioner. Also, that, again, would keep her from appearing at petitioner's workplace or residence, or sending mail to him, or contacting him by phone in this particular matter, or from threatening to kill or injure him in any way. The court will not enter an order which would prohibit her from possessing a firearm, and the court will keep this in place for a period of 1 year that will allow you to get past the period of time of your divorce act, and hopefully things can settle down at that particular point. So that will be the order of the court. We'll do that, and then that's how we'll proceed.
I think
And that will conclude the matter. And Mr. Pediac, you can come down to the court, and the PPO coordinator, and she'll assist you in getting a copy of that, etc. Okay.
I don't know why she's breaking down now. I don't know why she's breaking down now. I think it's because she realizes that she is no longer in control. As well, it should be. Neither of them should be in any type of favorable or unfavorable control of the situation. So, it was a good call. It was a good call from Judge Kirkham. And that's going to do it, guys. Yeah, she could stay mad. She could stay mad.